When it comes to enforcing arbitral awards in India, not all parts are created equal. While international commercial arbitration awards benefit from a well-established statutory framework under the Arbitration and Conciliation Act of 1996, making enforcement relatively seamless, the same cannot be said for BIT awards or arbitral awards under bilateral investment treaties. So let's unpack what challenges you're up against if you're looking to enforce one of those. To begin with, India is not a party to the ICSID, that is, the International Center for Settlement of Investment Disputes Convention. To put it in context, BIT awards under ICSID have an immunity from being challenged in national courts. The Indian Code of Civil Procedure does allow for enforcement of a foreign judgment, but then a bilateral investment treaty award is not considered to be a judgment. Which brings us to the only framework available for enforcement of BIT awards, the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or what we call the New York Convention. Now, the New York Convention has been integrated into the Indian Arbitration and Conciliation Act, but there too, India has made two reservations. First one, commercial. India enforces awards made in the territory of only those contracting states that have been notified as a reciprocal territory by the Indian government under the Arbitration and Conciliation Act. And second, India applies the convention only to differences which arise out of those legal relationships, whether contractual or not, that can be considered commercial under the national law. Which brings us to the very obvious question: are BIT disputes considered as commercial under Indian law? Now, the High Court of Delhi has ruled that BIT disputes are not commercial because they arise out of state guarantees under public international law, not private agreements. However, India's 2016 model BIT and the recent treaties like the India-UAE and the India-Uzbekistan BITs classify such disputes as commercial. Now, this raises some very difficult questions. For instance, whether issues under the older BIT model can also be considered commercial for enforcement purposes. Even the reciprocity reservation is not easy to navigate. For instance, although the India-UAE BIT considers any disputes which arise under it to be commercial, the UAE has not been notified as a reciprocating country under the Arbitration and Conciliation Act, which further complicates the enforcement. Another emerging global obstacle is sovereign immunity defense. The recent cases in the UK and Australia have upheld India's sovereign immunity, preventing enforcement of BIT awards. The UK government has gone a step further and stated that merely ratifying the New York Convention doesn't waive sovereign immunity against enforcement. Interestingly, the Delhi High Court took a pro-enforcement stance, rejecting Afghanistan's sovereign immunity defense and held that an arbitration agreement is a commercial contract which implies a waiver of such immunity. While India has made strides in clarifying the commercial nature of BIT disputes, the enforcement landscape remains challenging. There are procedural hurdles and an evolving global jurisprudence on sovereign immunity. All in all, there is a clear need for India to reconsider its reservations under the New York Convention if the end goal is to boost investor confidence.